Hi, I'm Tom Martin. I'm the CEO and founder of LawDroid, and we're a company dedicated to helping lawyers supercharge their law firms with the help of AI legal assistants that can help with everything from case law research to analyzing documents to even capturing new leads. The session you're about to watch first aired live at LawDroid's first annual AI conference. One thing I would ask of you is to please keep in touch with us. You can subscribe to LawDroidManifesto.com, which is a newsletter where I can keep you updated about the latest developments in law and technology, and let you know about great events like this that'll keep you informed and that you can walk away from with actionable intelligence. Stay tuned.
Just a couple of brief introductions. I'm Sari Montgomery. I am a partner in the law firm of Robinson, Stewart, Montgomery, and Dopke in Chicago. And we have a practice focused on legal ethics, representing lawyers and judges in discipline cases and giving ethics advice to lawyers and law firms, government agencies, and law-related businesses. So we've been very busy lately. And I'll let Jayne and Scott introduce themselves briefly.
Hi, everyone. I'm Jayne Reardon. I am a partner and deputy general counsel of Fisher Broyles, LLP. Before that, I had a legal consulting business where I focused on legal ethics. And prior to that, I was the executive director of the Illinois Supreme Court Commission on Professionalism. For quite literally decades, I've been writing, speaking, and studying the intersection between ethics, professionalism, and the practice of law. So I'm excited to be here.
Good morning, everybody. My name is Scott Kozlov. I'm the Chief Ethics Officer and Legal Counsel for the Cook County Clerk's Office. I'm also currently an adjunct professor at Loyola University in Chicago, teaching professional responsibility. I spent 20 years as a disciplinary counsel with the Illinois Attorney Registration and Disciplinary Commission. And most recently, I served in the capacity as director of unauthorized practice of law litigation for that agency. I'm happy to be here and excited about this program.
So this is a little bit of a full circle moment. I realized as I was preparing for this because shortly before October of 2022, Jayne asked me to join a panel for the American Bar Association School on Unauthorized Practice of Law. And on that panel were Tom Martin and Amanda Brown, who's also presenting today, and also Tricia Rich. So she said that the title of the panel was going to be about bots practicing law. We thought, oh, that's such a great topic. Really interesting what's going on with, the development of using technology to deliver legal services and all of that. And so we prepared and we gave, our presentation in October of 2022. We were then asked to do it again in February of 2023. And, what do we know happened in November of 2022? ChatGPT happened. And so we've since given this talk on ethics and AI a number of times. And looking back on our presentation in October of 2022, I think to myself, oh, that was so cute. We were talking about the ethics of, decision tree models and things like that. And little did we know what was coming. So this is definitely has been an evolving program. And we're excited to talk to you today about the ethics. Interestingly, although the technology has evolved, at lightning speed, the ethical issues involved really haven't changed all that much. It's just that we have to apply them in a different way. So we're going to talk about the main ethics rules that apply to using platforms like ChatGPT and other generative AI programs. And hopefully you'll come away with a good idea of what you need to be thinking about when you use generative AI tools. Just a few resources to be aware of. I caught part of the last session, and I know they mentioned a couple of these, but Florida just came out with the first ever ethics advisory opinion in the country. California has issued guidance. And then those are the only two opinions or guidance we have in the United States, but the EU has also issued guidelines. Recently, the UK and Wales issued guidelines. And then we have, as we'll talk about a little bit later, there have been a few individual tribunals that have issued orders that you should be aware of if you're practicing in those jurisdictions. I'm sorry.
Can I just chime in for a second? That California guidance website link is particularly helpful. You know, it operates as a clearinghouse for all materials related to AI and ethics. So they continually update that site, and it's a really good resource if you want to check back to see if anything new has come out.
Thanks, Scott. That's super helpful. The other resource that you should be aware of and might want to consult is your malpractice carrier. I spoke about AI and ethics last fall with a group of carriers and general counsel, and it's interesting because they don't all have a uniform approach to how to manage the use of AI in law firms. So I definitely would encourage you to consult your carrier. Some carriers have sample policies that you can use, and some carriers don't want you to have a policy. They just would rather you have guidelines. So definitely worth consulting your carrier to see what approach they recommend. So let's get started with talking about the specific rules that that we want to look at when we're using generative AI tools. So we're going to start with Jayne. Can you tell us a little bit about competency, being diligent, and using independent professional judgment?
Sure, happy to jump in. Those are the rules at the beginning of your rules of professional conduct, right? We all have the duty 1.1 to maintain competence, and typically and explicitly that means having the required knowledge and skill to reasonably represent your client. And it will vary on the representation, of course. But in 2012, the ABA modified a comment to that rule, which has now been adopted by 40 states, which is called the tech competency requirement. And it explains that in order to be competent, to have the requisite knowledge and skills to adequately represent your clients, you need to maintain or keep abreast of changes in the practice of law, including the benefits and risks associated with the relevant technology, including the benefits and the risks. So to take the position, this is risky, we're not going to engage with technology, is not maintaining our ethical duties of competence. And in order to diligently, that's rule 1.3, represent a client, you need to understand, I certainly will not be a coder or really get into the deep workings of AI and generative AI products. I certainly play around with them. I know them. I understand how they work. And that's what we all have to do, is understand what is going on with these new generative AI products, and why does it feel different? I know the last panel said, well, we moved from snail mail to email, from landlines to cell phones, and we made these transitions as adults, members of society, professionals, relatively seamlessly. This transition seems a bit different, and it is different because of the nature of the product that we're dealing, the generative AI. So we've also already had a couple of folks give us the horror stories that happens if you don't understand what you're dealing with and file a pleading. For example, Attorney Schwartz in the Avianca case in the Federal District of New York filed a pleading. There were case references received from ChatGPT. He plopped them into the pleading, and didn't check them, and the cases actually did not exist. And ways some of the people talk about this is, ooh, the product hallucinates, the ChatGPT hallucinates. Well, that's ascribing human characteristic to quite a mechanical process, right? No, there's no hallucination going on. How these large language models work is simply predicting the next words in a language sequence. It's very straightforward. These machines don't think, we think. We have an obligation as a lawyer to check and make sure the output is accurate. And in fact, that attorney didn't do so, and then doubled down when the court questioned him on the fact that nobody seems to be able to find these cases, counsel. So in fact, I think he got away fairly with a light rap on the wrist with only a $5,000 fine for what he did. There's been other very kind of high profile cases that have gotten a lot of notoriety in the last 6 months. There's the rapper case. That attorney is represented Pras Michel, and the judge is now considering a motion for a new trial because the rapper says, nope, attorney used a AI product in the closing argument and it was gibberish and it wasn't effective. That's still pending, but meanwhile, unfortunately, the attorney is suspended for violating a protective order in disclosing discovery materials. There's another case, an attorney, Craybill in Denver, was suspended for 90 days for doing very similar to what the attorney in New York did, filed a pleading, didn't check the case citations, and then blamed it on his paralegal. And we'll talk about that. I mean, lawyers, that's not a defense, right? We're obligated to check the work of the people who are doing research or writing at our behest, and we're responsible to make sure it's accurate. So he got a 90-day suspension. And then another very famous case you might have read about, Michael Cohen, Trump's former lawyer, his lawyer coincidentally also named Schwartz. So maybe the lesson is stay away from Schwartz's in the ethics area. Filed a pleading to shorten up his probation based on case citations that Cohen got from Google Bard that didn't exist. And so he got in trouble there. However, in all of these cases, it's not a problem with the generative AI product. It's a problem that the attorney didn't follow basic rules of competence, diligence. And then the third one that Sari mentioned is use your own independent judgment. That's Rule 2.1. Lawyers have an obligation to exercise our independent judgment and render candid advice. If we are relying on case citations spit out from Westlaw or ChatGPT or any other product that we don't check, we're not following the ethical rules. So as Sari said, the rules are there, and in my opinion, I don't think they need to be changed. We just need to have to recognize this is a new tool, but we still have to abide by our ethical rules. And some of those rules require client communication or communication with the client. And so I'm going to pass it along to Scott to address, do we need to involve our clients in this decision-making?
That's a really good question, Jayne. And, I do think that we have to contemplate our duties of communication. But before we move on, I think it's important to not only think about what's clearly happening now. What are the issues now? What are the ethical dilemmas that people are facing at the moment? But also to be forward thinking, right? So I look at the duties of diligence and competence as something that's evolving, right? And particularly with AI, there may be a point, we're not there yet, but there may be a point at which we reach a duty to use AI, right? We've had tools that have come about in the past that now are mainstream. Taking, for example, case history, right? When you look at the precedent that you're citing in a brief, you immediately check that case history on Lexis or Westlaw. I'm not even sure you can go to the paper manuals to check that case history anymore. I think you have to do your due diligence and comply with 1.3, in the rules of professional conduct, and check that history. There may be a point in the future where we reach that issue with AI. Do you agree?
I absolutely agree. There's been cases where lawyers have been disciplined for failing to use e-discovery tools, for example, which when they first came out were very scary and not mainstream at all. But the rules of our profession need to be flexible enough to apply to new technology that makes it more efficient and more effective for us to deliver legal services for our clients. So yeah, that's a really good point.
And not only will the ethics rules require it at a certain point, but I think even before that, clients will start to demand the use of it because it eventually will create such efficiencies that they will demand it.
Great point, Sari. So the duty to communicate with clients about the use of AI is truly unclear. When we look at the rules regarding communication, we don't get a clear answer as to whether or not we need to convey to our clients that we're using AI to pursue their claim. Rule 1.4 in the Rules of Professional Conduct contains several provisions that could apply to this issue. 1.4A1 makes it clear that where the client's informed consent is necessary to make a decision about how to proceed, that we must communicate with the client about that process and that decision. 1.4A2 says that when we reasonably communicate with clients about their cases, we're talking about the means used to accomplish their objectives. We have to communicate about the means that we're using when pursuing client claims. And finally, 1.4B tells us that we need to keep clients reasonably informed about the status of their case and to explain to the extent necessary, what we're doing in matters so that clients are informed about how to proceed, about how we're proceeding with their matters. None of those provisions really gives us clear guidance on, what is it that we need to say to our clients when we use AI? Have we ever been required to tell clients that we used Lexis or Westlaw in researching the case law on their claims? I don't think so. I don't think that there's ever been an affirmative duty on lawyers to make that kind of disclosure. There is a requirement that we communicate with clients about how we're expending our time. I know this is jumping the gun a little bit, and Sari's going to touch on fees a little bit later, but we do need to communicate how we're expending our time and earning our fees. So if that means explaining what we're doing with AI to generate a document or to proceed with a brief, then we do need to communicate. But I'm not sure if the other experts disagree with me on this. I just don't see that there's an affirmative duty in the rules as written to communicate with clients each and every time we use AI to pursue their claims.
I agree with you, Scott, and I don't think I'd be competent to even fulfill that duty because, as we all know, AI is infiltrating a lot of our everyday tools that we use, Copilot, Microsoft Word, so to think that I could identify the use of AI or possibly generative AI right now, but in the future, they will become so ingrained in our everyday work tools that I don't think we could possibly convey that information accurately.
Yeah, and on a related note, I do think it's important to watch the rules of the tribunals that we're practicing in. Sometimes there is a need to disclose. The Fifth Federal Circuit, for instance, is considering a proposal to require attorneys to disclose when they've used AI in the preparation of documents that are filed before that tribunal. If there is that kind of regulation in the jurisdiction in which you're practicing, we're going to need to make those disclosures. So, it's not just a matter of looking at the rules of professional conduct. It's also a matter of looking at the specific jurisdictional rules in the jurisdiction in which you're practicing. So, Sari, I think that covers communications, and we can move on.
And I think that's a good, what you're talking about as far as client consent is a good segue to the next ethics issue that we're going to talk about, which is confidentiality of client information. And I'm going to take a little bit of issue with the notion that you don't need to get client consent when you use AI tools. I think that that's true, certainly true of some AI tools, certainly Westlaw, Lexis, that there's no reason, and historically we haven't, needed to get client consent when we use those types of tools. But I think generative AI platforms, depending on what type they are different. And that's because some of these tools take whatever we input into them and absorb it and use it as fodder for their next, the next response that they are going to provide to the next user and the next query and the next prompt. So to the extent that you are using an open generative AI platform like ChatGPT, like Bard, like any of those, I think you have to be very careful about the information that you input into those tools, because they can end up being used the tool accumulates that information and uses it going forward. So conceivably, if you put client confidential information into, or any client information into it, for instance, if you are a patent lawyer and you put in information about a particular invention that your client is wanting to patent, that information, you have lost control over it if you were using an open generative AI platform. So I think in those cases where you are using open platforms like that, it may be necessary to get client consent, informed consent, before putting in any client-specific information into the platform. Now, there are some firms and there are some platforms that have been developed that are closed generative AI systems, closed meaning to the firm. So nothing that you put in can leave the firm. So those are a little bit different because that does offer additional protection. But there's still maybe the risk that, that information that you put in could then be transferred to another lawyer who puts in a prompt and that generates a response that includes the information that you put in. And perhaps that, other client, may not be entitled to have your client's information. So I think, it's still so new that we have to be very careful and cognizant of the confidentiality of our clients' information when using these platforms. So I think there are a lot of other uses for it that you can use without putting in client information. So, but again, I think it just depends on the platform you're using and what type of information you're putting into it to make the determination whether or not you need to get client informed consent. And I think it's also to note that this duty to do that evaluation applies to prospective clients, current clients, and former clients, because we owe duties of confidentiality to all of those clients, regardless of what their status is, even if we never take on the case. So that's something to remember also. And confidentiality is probably the number one concern of carriers and lawyers in using these platforms because we don't exactly know how the output is generated. So it's really hard to know what's going to happen with the information that we put in to the platforms. So with that, it's our responsibility to know as much as we can about how these platforms are work and how they're going to be used. So Jayne, can you tell us a little bit about what our responsibilities are as far as supervising these tools?
Yes, thank you. Under the model rules of professional conduct, which have been adopted by all the jurisdictions, lawyers have a duty under Rule 5.1 if they manage a firm or supervise someone else to make sure on the management side that there are adequate protections in place to ensure that the lawyers in the firm are abiding by the rules of professional conduct. And if you're supervising a lawyer, you have to make sure that that's the case as well. That's Model Rule 5.1, and that applies to everything, not just the use of technology, but all the activities of the practice of law. There's also Rule 5.3, which was modified in 2012 by the ABA and subsequently adopted by most jurisdictions. That applies to, I hate to say this, but that's the rules say non-lawyers. Lawyers are the only people, I think, that divide the world into us and them that way, but that is the way the rules are written. And that rule says that lawyers need to supervise non-lawyer assistants, ANCE. It used to be assistants, ANTS, which refer to people, right? Of course. But it has become clear over the last decade that the duty applies to outside vendors, provision of technology services, document production, scanning, whatever. And there are specific examples in the rules. These rules together make clear that that lawyers have to know what's going on in their firms with their colleagues and with the products that we use to deliver legal services, and make sure that folks are exercising conduct that is compatible with the rules of professional conduct. So that is kind of a high order to put on lawyers, many of whom have been at the top of their firms practically, for a while, that they really have to understand what's going on and make efforts to ensure, as Sari referred to, guidelines or policies or whatever procedures are in place so that the services are being provided in a manner compatible with the lawyer's professional obligations. Again, it's not going to be a acceptable argument that, oh, I hired an outside vendor and they didn't do it right. No, it's clear that it is our obligations then to make sure any generative AI platform we use complies and the lawyers using it comply. So that's important for us to kind of know that this is squarely within our ethical rules. I haven't seen any cases yet on this point. I don't know if Sari or Scott have, but I would not be surprised if they come down the pike. Again, this is such a new and evolving area. It's hard to know.
I think that might have been an issue in Avianca if the lawyers involved had not both been, very experienced lawyers. I think that if one of them had been an associate and the other had been a supervising attorney, there might have been some discussion of that responsibility.
Yeah, but they were colleagues, as I recall. So
right. Correct.
So these, another area, and I know Sari and Scott have talked about this a lot, where, you know, we're butting up with technology, bots, and the practice of law brings us to UPL, the unauthorized practice of law. And what do we need to be aware of about that, Scott?
Yeah, the prohibition against the unauthorized practice of law is found in a variety of sources, which differs by jurisdiction. Some states have criminal laws prohibiting the unauthorized practice of law. Others rely on civil statutes to impose civil penalties or injunctive relief for the unauthorized practice of law. The sanctions differ. The mode of enforcement differs. For non-lawyers violating criminal laws, this could mean, jail time. We could be talking about sending somebody, to jail for engaging in the unauthorized practice of law. For lawyers who engage in the unauthorized practice of law, we generally look for guidance in Rule 5.5 of the Rules of Professional Conduct. That rule basically says that lawyers are prohibited from practicing law in a jurisdiction in violation of the regulation of law in that jurisdiction. This concept, generative AI, really puts us at the cutting edge of what is the practice of law. We have to ask ourselves whether or not the machines are practicing law, right? That's the ultimate question. Are the machines thinking? Are the machines making legal determinations for people on legal matters? My position is that generative AI is not the practice of law, that you still need to input information into the tool to confine the task that you're asking AI to do. I think that it's clear that we still need to lay down the parameters of the task before the tool, the generative AI, engages in any kind of work whatsoever. So because there is, human involvement there, I think there's still ultimately somebody responsible for beginning that process. The line between what is the provision of information and what is actually the practice of law is a little bit blurred. We're talking about something that creates new concepts that we haven't really anticipated before, and the rules weren't written for that kind of situation. So in this case, when we're talking about the unauthorized practice of law, I need to point out that almost all jurisdictions enforce UPL regulations by looking for a victim. They're looking to determine whether or not somebody was harmed and who engaged in conduct that created the harm. Because of those general guidelines, I don't see AI as, or generative AI as something that's going to lead to, an influx of UPL prosecutions. Do I foresee situations where AI leads to prosecutions for UPL violations? Absolutely. And let me explain. I can see a situation where an unscrupulous individual uses AI as subterfuge to impersonate an attorney and to produce a legal product on behalf of a client for a fee. If that's the case, the individual that did that needs to be prosecuted. And I do think there's a place for UPL prosecutions in those situations. Just by somebody putting in a task into a generative AI database and producing a document, do I consider that the unauthorized practice of law? Maybe in the traditional sense, thinking back 20, 30 years, that would be something considered to be the unauthorized practice of law. I think we're beyond that point. I don't think that amounts to the practice of law that should be prosecuted under UPL regulation. Simply using a technological tool, an advance that we're now encountering in societal practice, doesn't amount to the unauthorized practice. Now, I think there are variations and there's gray area in between, but trying to sum this up in 5 minutes, I do think we need a victim, and we need some human involvement that would cause us concern over the conduct of that individual.
We could probably debate that for about an hour, just that issue in and of itself. But I will point out that although the definition of the practice of law varies from state to state, I think a classic definition is the application of a law to a specific set of facts. And you don't always have a lawyer inputting the prompts into the platform. So I tend to think that this is the practice of law, which is why it's important for lawyers to make sure to supervise that practice and ensure that that it's being used properly and that all safeguards are in place to protect the clients. But I digress.
No, that's right on point. If I could just add one more thing, and I know we don't have time to go into this, but this is a pet peeve of mine. The regulation of the unauthorized practice of law lags behind decades. And in some jurisdictions, as Sari said, it is so broad. In some jurisdictions, it's literally whatever lawyers typically do or have typically done is the practice of law. And that does not serve society well. That's chilling the innovations and the entrance into the legal field of people who could make a huge difference here, but they're like, well, I don't want to get prosecuted for UPL. I'm not a lawyer. So I think we as a profession definitely need to address that issue. And I don't see the courts jumping up and down, taking on that task in the near future, but then I digress.
Which brings us to the topic that we discussed briefly, and I think was touched on in the prior session, which is Rule 1.5 and the obligation to charge reasonable fees to our clients. And I think for a long time, there's been a movement in the profession to try to get away from the billable hour. And I don't know that very many lawyers or firms have been very successful in that. Firms that typically use that model to charge their clients. Obviously, there are some practices that lend themselves more to flat fees and other types of fees than the billable hour. But I think in general, that has been a predominant fee model. And here, once we get to a point where these platforms, we can use them reliably, I think they will save an enormous amount of time. But that doesn't necessarily mean that the lawyer's expertise in getting that outcome should be discounted or disregarded. So I think that this will really light a fire under lawyers and law firms who typically use the billable hour to find other ways to value the services that they provide other than the billable hour, because as we've seen, the use of these platforms really just completely, it can take something that would take an associate, 3 hours to research and write. It could take a platform like ChatGPT, seconds to do. So we have to find other ways to show the value of our services. And, and it may be that some of the services that are now provided by lawyers or billed by paralegals or other paraprofessionals, we might not be able to bill out those services to the clients anymore, because it is a function that can be done without, significant legal input, especially repetitive tasks that you do for every client. I think that is certainly something that, perhaps that service might transition to a flat fee or some other model. But, we have to keep in mind that lawyers are obligated to only charge reasonable fees. So, certainly we can't charge the client for more time than it actually takes to do a task. That is, not only not reasonable, but it's also misrepresenting the time that it takes to perform a task. So we either have to find a better way or different way to value our services, or we're going to not be billing nearly as many hours for certain tasks as many firms have become accustomed to. So I don't know what the answer is to how to charge for this, but certainly I think there is value. Lawyers do bring value into using these tools. So I think that there will be a reasonable way to charge for it. And speaking of being candid with clients and others, Jayne will talk to us a little bit more about that.
Yeah, thanks, Sari. And Scott mentioned this earlier. We just want to touch on the lawyer's duty of candor toward courts and the tribunals. And he mentioned that the Fifth Circuit Court of Appeals has a proposal that I think is still open for comment. Most of the comments garnered to date have been negative, requiring that lawyers and self-represented litigants disclose to the court if a generative AI product, if an AI product, not even generative, was used in the preparation or of anything filed before the court. And other courts, federal courts in Texas, in Illinois, and in Pennsylvania, in the wake of that Avianca case, also issued orders. You must disclose if any of your pleadings were the result of an AI product. So you have to be aware of what's going on in your jurisdictions on this point. My personal view is this is a misguided requirement that we should not have courts issuing. And I also, if you want a counterpoint by a judge, which is really very well written, Judge Scott Schlegel, who is from the 5th District in Louisiana, writes a blog. He's very into technology. And he has an open letter to his colleagues. He says, don't do this, folks. We have Rule 11 and the state counterparts, which say, if you sign a pleading, you're verifying that the facts and law are accurate. That's good enough. And there are other rules that require candor. And I get it. Look, the bedrock of this rule is we want courts to decide controversies based on accurate facts. That's why lawyers have to make sure they don't put forth evidence they know is false, etc. But the use of AI tools is becoming so ubiquitous and is not needed to regulate behavior. As we've said already, lawyers have an obligation to check, and so should self-represented litigants understand that they have to be accurate, and they'll do the best that they can. I don't think we want to muddy the waters, personally, with more orders issued by different jurisdictions that may conflict with each other, and again, may chill developments in this area, which has the promise of really making impactful changes in the practice and delivery of law to so many people who could use legal services. There are some very big concerns in this area of the duty of candor toward the tribunal. Is what do we do about deep fakes? How are we lawyers supposed to know, is our evidence created through a tool? So that's, I don't know the answer to that. I don't know how to do that. I don't have the technological background, but that's a better inquiry. And I do know that courts across the country are trying to look at this issue. And just in the last month or so, the 9th Circuit and the 3rd US Circuit have convened task forces to look at these issues globally. How are we going to be handling evidence in light of this ability of technology to create evidence? And I want to just mention, we didn't get a chance to mention at the very beginning, the ABA has an AI task force looking at this issue, and the Center for Innovation also is looking at this issue. So I'm hopeful that will have some thoughtful guidance going forward on how to harness the great potential that we see here and keep the ethical bedrock of our profession intact. I think it can be done. It's not threading a needle, folks. We are problem solvers. We can do this. And I don't think the answer is stay away from AI. It's dangerous, but that's just me. I'm going to turn it back to Sari. I think there's a few questions that have come in that we might be able to address in our 5 minutes that we have left.
I've been trying to answer the ones in the Q&A as we go along. There are a couple in the chat, and I think as Tom's noted, we can't answer the ones in the chat, so you have to put them in the Q&A. But we only have about 5 minutes left, so before we go to the live Q&A, I think we each wanted to have a takeaway that we wanted to leave you all with. So Scott, did you want to give us your words of wisdom?
Sure. I don't know how wise they'll be, but I'll try. Tom asked us to leave you with one message. If you remember anything, remember one thing. And that's so hard to do in this context. But I would say, obviously, it's important to stay abreast of the changes that are happening with respect to AI, not just the tool itself, but the rules that impacts the use of generative AI. Beyond that, I would say it's also very important to get involved in the process. The jurisdictions all have convened committees or task forces to try and study this issue and to modify the rules as needed. And I think there are many outlets for that. Jayne just mentioned the ABA, the Center for Professional Responsibility has convened a committee to study this issue. There are many, many outlets for you to get involved. And I think, it's important as people that are on the cutting edge and interested in this topic for you to be a voice in the process while we're changing these rules.
Jayne?
Yeah, I kind of summed up when I was talking about the courts, but building off what Scott says, I agree that it will be, and it's very helpful for lawyers to be involved in the process, learn about AI, generative AI, what it does, what it can do, and get involved to change the process of the delivery of legal services. Because in my opinion, we are at an inflection point here, and I think someone said this already at this conference. There is so much promise for us to move forward by harnessing the possibilities of generative AI. I've never seen in the couple of years I've been practicing law so much change so quickly. And I think it's a very optimistic time. It's a great time. And someone mentioned a question about AI prompts. There's going to be all sorts of opportunity to practice in law adjacent fields as well, I think. So it's a great time to just grab it with both hands and leverage the possibilities.
And I would just sum up by saying, again, akin to what Jayne is saying, this is a time of great opportunities. And I think that we've already seen how technology can create greater opportunities for access to legal services in some of the models happening in Utah and Arizona. And I expect that will just explode. So I applaud everyone working in the space for helping to make legal services more accessible. And I think that the use of AI will really be a game changer in that respect.
That was another great session from LawDroid's first annual AI conference. Thank you so much for watching. Please keep in touch. Subscribe at lawdroidmanifesto.com, where I can keep you updated about the latest developments at the intersection of law and technology, and let you know about great events like this. Keep in touch.